you. Thank you.
I definitely see how I understand what everybody's saying, and I understand, especially as I've learned more as I transitioned into the government relations role on how this works. And I see what Alan and Mariana are saying, where tenants could see this potentially as a loss in profit, even though it shouldn't be. And I like, I personally like the idea about the shared one-time fee cost. I don't know if any of that has been discussed. I'm happy to ask. I do know that we have presented this rate case plan and discussed the mobile home rider with all but one of the city council members. We have one more meeting to do on September 11th. So we have met with all of them, and we have also briefed all of the Board of Supervisors. So they all are aware that we have this plan in our rate case. And so we are talking about it within the community.
So I didn't pretend to understand much about rate increases, but I assumed when you started talking about it, there was something that was done with the ACC. But now I'm getting the idea it's the city of Tucson, or are they both involved, or how does that?
There's a public hearing. It goes to the ACC. We filed with the ACC, and there is a public hearing, and people can come and testify against it or show support for it. Ultimately, the ACC makes that decision on the rate case. So, part of it is when we go out and do our rate case, and just a real quick snapshot, we're recovering costs with a rate case. So our increase is based off of a 3-year time period from the last rate case. So we're not looking ahead at increasing rates. This is money that we're recovering that we've already spent. And so we want to make sure that everybody understands that. So we meet with our elected officials to explain that to them, along with like chambers and everybody else. And then we also go over what else is in the rate case. For instance, we've added some great new incentives for Budget Billing and Lifeline that will potentially offer a greater discount to our customers. And so making sure that they see that that's in there as well and what we're trying to do. So that's the goal of meeting with our elected officials and explaining it to them as well as they're looking at the rate case. But the ultimate decision is from the ACC.
I think one place that there might be an incentive for this is that you may have seen that the Attorney General's office is using their regulatory power to start to enforce the Mobile Home Park Landlord Tenant Act related to utilities. There was a cease and desist letter that was issued maybe 2 weeks ago at Redwood Mobile Home Park, who's not been providing electricity regularly. And to me, that kind of park is exactly the kind of park that would be a great fit for this. It's a park that's going to have a very costly repair fee to get into compliance with their electricity service. They don't have sufficient infrastructure electrically to serve that park. So I could see this being in cases where the park is going to get sued if they aren't providing electricity, that then they will say, oh, here's an easier way to help to overcome that barrier. The one thing I would say is if there's any public support, I would want to ensure that it was public support that came with an agreement around limits on the amount that the property owners can raise rent. I wouldn't want us to see public funds to subsidize a mobile home park landlord to say, oh, we'll cover that $500, and then they're just going to go charge residents however much they want. Yeah, I would want to see that as.
And I'll just add to what Ray was saying. We met with team staff from the Attorney General's office last week when we were at a conference up in Phoenix and briefed them on the mobile home park rider. And I do believe in just briefly hearing other discussions and looking at my colleagues' meeting that they're actually meeting with the AG today. If that's to talk about mobile home parks, I do not know, but we are in communication and working closely with them. And I know that they've been briefed on the rider. Alan, did you have a question?
I do.
No, I don't know if I raised my hand improperly, but I don't think I did.
Oh no, actually my cursor looks like a hand and it's over your picture. So sorry, that's me.
Can I ask a question?
Yes.
Okay, so in dealing with utility, I'm from Amho, and we're really working on trying to get some bills this next session on utilities. And the one about how utilities are billed is one issue. And the other one, the huge one, which you guys are addressing right now, is how to pay for the infrastructure to be upgraded. And I know that a lot of parks, what they do is they just go in, buy the park, do some superficial fix-ups, raise the rent, jack the rent up high, and then sell the park again without fixing any of the infrastructure. And what you guys are talking about doing is having the utilities actually be able to come in and directly bill everybody, and they would be responsible for the utilities all the way up to the house, right?
Yes. So right now, our infrastructure stops at the meter. So anything that happens at the park, we can't support.
Right.
Just as if these locations went from master metering to individual metering or customer meters, we would have to come in and put new infrastructure in because that infrastructure is not ours. We don't know what type of shape it's in or how it was, or, we don't want to take responsibility for something that may not be up to our standard. And so we will come in and put in the proper infrastructure or what we use as an infrastructure into the parks. And then we would work with each customer individually. So if there was an outage, we would go in and address it with that customer. Same as now that we would be able to do the billing for each customer individually.
And customers would be eligible for any kind of incentives offered by the power companies, which we are not now if we're master metered,
Correct.
like where I live. Yeah.
Right.
Okay.
Correct.
Wow. I think it would be an incentive to the owners, the big owners even, because they know that this infrastructure thing is staring them in the face down the line. It's going to happen because these parks are old, right? And they're going to have to sink millions of dollars into doing this. So there's the one incentive for the owner. I mean, I know they have to pay the fees, but I don't think that's going to be as much as it would cost to actually do it themselves. So have you run the numbers on how much it would cost for the park to actually do it themselves and how much it would be with if they had to pay the $500 out front for, it's $500 for each unit, right?
I would have to clarify that. I believe it is. Yeah, Ray's shaking her head. Yes, it's $500 per unit.
Yeah,
But I can confirm that as well. And I don't know if we've ran the fees of what it would cost. It would be my assumption that, each park is so different and unique in their infrastructure that the cost would vary greatly depending on the location and what you're doing and how many homes you're servicing. But we are trying to find a way to help the parks transition and fiscally be responsible with that.
I think it's an awesome idea. Go for it. I'm jealous. We're over in Mesa. Hmm.
Thank you so much, Tara, and for all of those great questions. Really
No problem. I'm going to work on getting you guys all the answers that you needed.
great. Thank you. And I'm pretty sure that the AG is meeting around master meter utilities with TEP right now, which is part of why Frank is not able to come today and give the AG update. So, I sent this out over the meeting agenda with links to each of these, but I'll just speak it into this space too. If anyone didn't get the email with the agenda for today that has all the links, please drop your email in the chat to make sure that you're on our email distribution list. Just a couple updates from the Attorney General's office. You've seen they put out a consumer advisory for master meter mobile home parks. And so this wasn't directed at one problematic park. This is directed overall to remind owners and operators of mobile home parks and residents of mobile home parks of what the law is related to master meter mobile home parks, with some advice on how to look at your meter each month, that bills should have an opening and closing reading each month, and where to go to make a complaint if that's not happening. That was also coupled with a cease and desist letter, as I mentioned, at Redwood Mobile Home Park to tell them that they need to provide sufficient electricity to that park that had over 16 times that the electricity was cut off this summer, and repeated water outages that's been happening for years. And finding that they were not able to come into compliance fast enough, they have now issued a publicly available announcement that they are filing a lawsuit against Redwood Mobile Home Park. The other thing that was announced this morning at the Attorney General's meeting with residents at Desert Haven Mobile Home Park is that they've been investigating that park as well. It's a Skyline Realty property. And in the beginning of that investigation, they're not that far along into it, So while there has not been a settlement reached or anything to that accord, they are issuing repayments to a number of the residents. So many of the residents are getting hundreds of dollars back. The Attorney General is saying that they believe that the residents have been overcharged for water for 7 years, and they are starting the process of investigating that. And she is saying repeatedly that let this be a warning to all of the owners and operators of mobile home parks in Arizona. If you are exploiting residents, we're going after you. So check the news today. I'm sure there'll be some press on it. But really grateful that she is taking action. The last update I had before we pass over to Mariana, unless anyone else has an update to bring us into this space, is we've been in a administrative law judge proceeding for the last year with Flowing Wells Mobile Home Gardens. It's a park in the Flowing Wells neighborhood that had errors in their electric bill last August and September. These were very well documented in multiple courts. They have said, like, yes, there were an error in the meeting readings. Over 36 people out of a 60-some lot park signed a petition saying that they were all victims of this, either victims of this overcharging or had seen these problems and were validating that of their neighbors. And in the end, which I guess is not really the end, but in this stage of the moment, the decision of the judge was that, well, quote, more likely than not, meter readings on some residents' meters were inaccurate. The administrative law judge has no jurisdiction to award damages. So I think that is a really important piece of information since, as many of you know, since you're familiar with the Arizona Mobile Home Park Landlord-Tenant Act, the Landlord-Tenant Act explicitly says if a park is out of compliance, the place to go to make a complaint is to file a complaint, to pay $50 to file a complaint with the Department of Housing and to have that go through the administrative law judge process. The administrative law judge is explicitly saying that it is not in her power to enforce the Landlord-Tenant Act or to do anything that makes a repair for harm that's happened. Again, I think there's very solid arguments for disputing that. And we're currently in conversations with the residents about asking for a rehearing and continuing to move forward because that decision is so dangerous for every resident of a mobile home or a manufactured housing community in the state of Arizona. If we're allowing that kind of decision to be upheld in saying that they actually just will have no jurisdiction, they could put down any number as long as they put a number and an opening and a closing reading, that they can charge whatever they want. So I'm happy to share more about that beyond this meeting too, if anyone's interested in continuing conversation there. Yeah, with that, we have such great guests today. So I want to pass it over to Mariana. Really deeply appreciative of you coming and sharing in this space.
Yeah, thanks for having me. I'd just like to share my screen. I have some slides.
Give me a moment.
Thanks.
You should have it.
Perfect. Thank you. Sorry, I'm just navigating all my windows.
Mhm.
Okay. So thank you everyone for having me to your meeting. I'm really excited to hear all this great news and the progress that's being made. Also completely understand that there's a lot more work to be done. So happy to be a part of that in any way. I did this research back in 2023 during my master's program at the U of A. I graduated then with my master's in public policy. Before that, I worked for TEP for 7 years in risk management. And so in that process of being there, I went out to a lot of calls, where whether it was storm damage or other incidents, to locations that were master metered. And that was like my first experience, seeing, the master meter layout for utilities, and gained an understanding of how it works, why it was set up that way, and then the issues that are presented. In that initial case, it was when like there was damage, and how do we get power back on if a landlord isn't willing to make repairs to equipment, and the dangers associated with that. So that was my first experience. And then I left TEP while I was getting my master's, and I started working as an intern at the city of Tucson. And in that role, I was working on the homelessness protocol, and we were given a bunch of information on evictions. And that's when I kind of started piecing everything together of like what happens for people who are faced with these enormous utility bills at master metered locations, who then get evicted as a result because they are not able to apply for utility assistance. There's no recourse, for them. So that's where this master's capstone project came in handy, for me to be able to explore those answers. So I feel like people already have a very good understanding of this, though, in this meeting. So I don't think it'll take too long. But I really wanted to look at this like policy failure at a local level. So during this time period that I researched, which was 2016 to 2021, there were 44,000 evictions that were filed. There are many causes, of course, that can lead to eviction, but housing cost burden is always like the main driver for eviction. And of course, there are many consequences associated with that, with eviction, and things that we should find like of high importance to prevent evictions from happening. So breaking down housing cost burden, I wanted to think about, okay, what is it? It's rent and utilities. Okay, the utility portion of that, how can we tackle that problem? And how can we look at these locations that are master metered? Number one, try to determine, are evictions happening more frequently at these master metered locations? And then what can we do to prevent evictions from happening at these locations? So as we all know here, master meters exist in Pima County, through TEP and also Tucson Water. I believe there are some Southwest Gas, but from my understanding, there aren't nearly as many. I was able to get unique data from TEP and the city of Tucson on all master metered locations. There are about 70 master meter locations for TEP, and there are over 4,000, I want to say. I'd have to look back at my writing. Master metered locations for the city of Tucson. So definitely a lot more for water, but there were far more like evictions associated with those locations, for the TEP utility, which in my opinion makes sense because TEP bills are that much higher typically than water bills. So my research question for my master's thesis.
Mariana,
Yeah.
I don't think we can see your slides. It just says loading on the page.
Oh, that's
I don't know if it's worth
frustrating.
fixing or not. Sorry.
Oh, maybe it's not worth fixing. I don't know why it's saying that. I'm sorry.
It's okay.
I know that Ray does have a copy of my slides, which I'm more than happy to have sent out now over after. Maybe I'll just not share my screen anymore. Thanks for interrupting me.
Sorry.
Oh, that's okay. I'll just pull up my slideshow just to reference. Okay, so does anyone have any questions now that you'd like to ask? Because before I talk about my research question, or okay, just making sure. Okay, so my question is an increase in the master metering rate associated with an increased eviction rate for zip codes in Pima County? And what I found was yes, and it was statistically significant. And it indicated that for every 1 unit increase in master metering rate, there is a 39% increase in eviction rate per 100 renting households. So this was a huge breakthrough while I was doing my research of just being able to prove. I feel like what I said, like we all already know in this meeting that the housing cost burden is a main driver. Part of our housing costs, our utility costs. When you can't get assistance because you're at a master metered location for your utilities, you're at a complete disadvantage for being able to stay in your home and not get evicted. When you're not at a master metered location and you have a utility account, you can apply for assistance. You have so much more like legal backing to help you through it, and utility companies cannot evict you. And so just I'm happy by these results that I had found, because it was just like I said, proving what we already know, that direct assistance for anybody, regardless of what type of meter they have, is necessary if we actually want to stop this eviction cycle that we are caught in, or just having to pay enormous amounts for utilities when you're not even like using that much of what they're claiming. So my recommendations at the time of my research, one of them was to tap into the Pima County Renter Assistance Fund. I think that's what it's called. Sorry, it's Pima County Eviction Prevention Program, but I believe there's an assistance fund associated with them. And to reduce the barrier to entry for utility assistance, that there shouldn't be this need to provide proof of using a utility. If you are living at a location, you are obviously using electricity and water. And there could be like if you're facing eviction, you can go to this fund and say, although I don't have a utility account, I can't pay my $500 electric bill. You know, here's my proof that I can't pay it, right? And then there should just be a direct cash transfer or payment to pay that utility. And I think that this could be like a pilot program where individuals that like are consistently having that struggle each month to pay their utility bills would receive the direct cash transfer from a county program to cover their utility bills. And then it would see, you could follow these households and see, did this relieve your housing cost burden? Were you able to pay your utility bill in full, stay in your home? I just think it'd be really important to try that kind of a program as well. I also think the utilities need to be held accountable more for filing when there's when charges are so high. Utilities don't want landlords profiting off of their service, essentially, and they should be holding those landlords more accountable. And it sounds like that's all happening, but that was, all part of my research as well. But I know that Ray shared my paper with everybody, and I really appreciate that, Ray. Thank you. So if anybody like reads through it and has questions, or if anyone has questions now, I'm here for it. Like I said, it was 2.5 years ago, so give me a little grace on the statistics. I'm no longer in Arizona, so yes, Kath.
Hi. This is so interesting to me. AMHO is right now collecting utility bills from residents so that we have evidence to show the utilities how much people are actually being charged.
That's excellent.
We will redact the personal information, but leave the park address and the billing amounts. And we intend to, the purpose of doing this is to be able to go to the utilities and say, look, you're giving them a special rate of this amount, and they're paying this amount per unit, and this is what they're charging them. And it might be 2 or 3 times as more. And we're finding that this is happening right now. And that was my question was, are landlords allowed to profit at all? I mean, I know they can have an administrative fee. Are they allowed to profit? I mean, I know it just seems so, maybe it's legal, but it seems immoral to me to charge the residential rate, even though we're the ones that got that put in there and in the law, that the residential rate, they have the right to charge that, the individual residential rate, but which might be like $47, and then they're actually paying $12.30, which is the case for one park we know about per unit, and they're charging the residents $47.
Yeah, I believe the only additional fees they can charge are that administrative fee.
Where does it
Um,
say that? Is that in the LTA or where is that?
I think Ray has that information potentially.
Yeah, they are allowed to make a profit under the current law. They are not allowed to charge more than the single family residential rate. So baked into that is the idea that they would be profiting off of it under the current law. But again, as you're saying, I think that's a great idea, Kath, to be tracking, especially if we can get every resident in a park to share their bill and then compare it to what TP as a whole is charging that park, to be like how much total quantity wise of kilowatt hours as well as money wise. There is, I think this was just in Colorado, they passed a law recently that, I'll get the exact language on it, that required more transparency, basically saying that any master metered park had to share their total bill as well, so you can know how many kilowatt hours were being charged the entire
yeah.
park.
That's a very well kept secret right now.
Yeah.
Well, AMHO would certainly appreciate help from anyone helping give us ideas for how to craft this legislation. And I don't know if other groups are also planning to propose other legislation outside of the county. I mean, you talked about the other thing, but you know, the session's coming up in January and we're working on this now. So please get in touch with me if you're interested in getting some input or helping us develop exactly what would be the most effective way to help our residents. Because they are, right now, they're acting like unregulated utility providers, the master meter people are. And that's wrong. And it may be legal in some cases because they charge the residential rate to the individuals. And even if we change to everybody was billed directly by the utility, they probably would then be paying the residential rate, but at least they'd have access to some of the programs to help reduce that. But what's happening right now is the park's paying often a discounted rate, if I understand this correctly, at least for some of the utilities. And then not passing that on to the residents, which to me is immoral, if not illegal. So
I agree.
Just one question, Mariana, and then would invite Ray for you to share what you said in the chat. One question I had was, if you could go back to that idea about the 1% increase in master metered in an area and a zip code, was it like a 38% increase in evictions? Can you explain that statistic?
Yeah, so I had to come up with a rate of like for master metered locations and an eviction rate in order to have like more easily understood across the zip codes in Pima County. So that's what I ended up doing for I did like a regression model on it. And I'd have to go back to my notes on my paper of like all of the detail in it, but I would be happy to do that and share it with you. I also have like all of the models that I ran that I can share if that would be useful. But yeah, it was a pretty surprising finding as I was going through it.
Does that mean that if there's 1% more master meters in a neighborhood, that 38% more people are evicted? Is that what
I
you're saying?
don't believe that that's the interpretation, but like I said, I'll double check.
Great,
Yeah,
thank
you know,
you.
yeah. And then there was a question in the chat.
I have a question. I don't know if that's the one you're looking at, but I have your paper up on my screen, but I haven't read it. But it starts off the number you said 44,000 court-ordered evictions in Pima County for 5 years, for 2016 to 2021. Those aren't all mobile home park evictions, or are they?
Evictions.
Okay, because the master metering thing doesn't really occur terribly often in apartment buildings and homes. It's mostly in mobile home parks.
Yes, they do exist though at some apartment complexes, from my understanding.
It can, but it's not common.
Yep.
So is the 39% an increase in evictions then would apply just to mobile home parks?
No, not just to mobile home parks. It was just,
Interesting.
yeah.
Okay.
And Ray, would
Oh.
you like to share this about how people can apply for LIHEAP?
Sure. I am by no means not a LIHEAP expert. However, I have someone who's very knowledgeable about it on my team, and PCOA does help individuals who are older and can't navigate that system on their own. But I know that we have helped individuals who are living in parks with master meters, and as long as they're willing to provide their bank account number on the application paperwork, as well as provide a ledger, a payment ledger from the park that notes how much they're being charged, they can indeed receive LIHEAP funds. And in those cases, instead of the funds getting credited to the person's TEP account, it'll go directly into their bank account. So they can access that at least. It's just a little bit more documentation and paperwork, which, as we know, can create barriers for folks who have a difficult time with that. So.
Mariana, I have a question. My name is Elise. I'm a, PhD student at U of A in geography. This is really awesome research. I'm curious. So, like, if the evictions in manufactured home, I'm just trying to think through this a little bit. If the evictions in manufactured home parks bring up the likelihood of eviction by 37%, then they must make up a decent portion of the total evictions happening in an area. Is that an accurate thing, or would you say that's?
I believe so. I have to, like I said, dig back into it and double check my like just what I did and make sure that what I'm saying is like now what I'm saying is actually what I did. So, but from what I remember, they do make up quite a bit of the evictions. And then in the paper, I also highlighted the top three zip codes where evictions were happening. And then the fact that there were master metered, that was also the highest number of master metered locations there. Bless you.
That's interesting. Thank you so much.
Yeah, sorry if that doesn't answer it fully, but
No, it's like that's helpful.
okay.
Thank you.
Were you able in that research then too to map out the total number of evictions that happen in mobile homes, regardless of whether it was master meter or not?
I wasn't able to because I had to make the data so that you couldn't figure out the exact location of the evictions. I went through the institutional review board for my project, and because it's sensitive information, that I was not allowed to go into that level of detail on locations.
I'm wondering, Tara, I know this might not be able to share officially on TEP since you are hearing this now, but I'm wondering, Tara, too, if you have any thoughts about what you're hearing here, especially around, I think your point, Mariana, about it being in TEP's interests to not have this being resold and to have opportunities for a little more accountability there.
I can talk more about how TEP doesn't like it.
Oh, I'd love to hear what you have to say on that.
If you're interested. When like responding to those incidents and everything, it was, oh, Tara's back.
I apologize. I had all of a sudden you guys went really quiet and it froze. So, could you repeat the question?
Yeah, maybe Mariana could word this better than I could. Just wondering if you have any thoughts, since there were some direct comments about things that TEP could do related to this, if you had any response to that.
No, I didn't really have a response. You guys are still really low. I'm so sorry. I don't know what happened with my audio. It like glitched. Here, I'm just, oh, here we go. Okay. No, I didn't have any direct responses. I listened to her whole presentation, which I thought was great. It just to me reinforced how beneficial this new rider would be for our community, and that it's needed. Ariana, you have TP history as well. Do you want to provide some feedback as well?
Yeah, I just know that from like personal experience of going out in the field and responding to like emergencies at mobile home parks where they were utility master metered, that residents would be left for weeks without power or without sufficient power or operating on like a diesel generator. And it's because, TEP can't make the fix past the meter,
Right.
which totally understand. Um, but also just the customer service burden that TEP would face when customers were without power for that long, because people would call in and day out, and wonder when their power is getting turned back on. Because I mean, it's confusing, right? Like you always think that like if your power goes out, call TEP, like that's what you're told to
Yeah.
do, and
Well,
everything. And then to like have that not be the recourse to get your power back on. I think that's like another challenge.
I also think that there's a lot of citizens that may not understand the master meter process if they've never experienced it or worked on it. So when you hear the power's out, it's not, oh, the landlord's infrastructure isn't working. It's TP, the power's out, right? And so for us, there's this false accusation point of what we're not providing, and we don't ever want to look like we're not providing power. Our goal is to keep the lights on 24/7. And so being able to control that infrastructure and have the services to go out and repair it and fix it promptly help us as well, just because, it's really, again, they're not going to know, people don't know that that's not us and we can't fix that. And it's not within, if you look at TEP and the way that we communicate, we typically don't go out and say, hey, that's not our power, it's not us doing that. That's not how we communicate with the public. And so to be able to restore as fast as possible would help with that scenario and mindset.
Yeah, and from like the troubleman perspective, so those are the people that like go out, first responders to the site to check power and everything. There have been instances where it's like a safety issue where the landlord is indicating, oh, we've made the repairs on our side of the meter, and they're like, no, like this does not look safe. We cannot turn power back on. So that's, I think, also just like a major issue that, like I said, would be in TEP's best interest to get more people off of master metered, and in a quicker manner and with less cost burden on the landlord, because I mean I truly believe that cost is going to get passed on to the customer at the end of the day, and just with the incentives of like the improved customer service and everything, I would hope that TEP and other utilities would just do a little bit more to help people get their individual meters.
Well, and this may not be applicable to this group, but just another point that TEP's been doing is I was actually part of the team, but we partnered with the Red Cross. I want to say it was at the end of May. Oh, it was beginning of May for Arizona Heat Prevention Week or Heat Awareness Week. And we went out into mobile home parks that were master metered and provided information from the Red Cross on what to do for heat resiliency and check on your neighbor during these times. Because we know that things can happen and infrastructure can go down and people can be without without, power during the hottest times of the year. And so we are very aware of what's happening, and we would love to be able to be part of the resolution to that situation. So like even the customers that aren't ours at this time, we're out there because at the end of the day, we're all neighbors and we want to help. And so we did do some of that this summer as well, because we recognize that there's a need for it.
A couple more minutes on this topic. Did anyone else have questions, comments? I saw Claire, you had posted something in the chat if you're open to sharing that out loud.
Yeah, thanks, Ray. I appreciate the conversation space. I do think it would be really great to figure out how to quantify the cost of not solving this issue for utilities. I've never thought about it in terms of the call center, but that's absolutely something that we hear about, people being like, I call my landlord, they don't answer. They say, I have no information for you. So then I call the utility. They say they can't give me information, but when you're out of power in the middle of summer heat, you're just going to keep calling till somebody helps you. So I imagine that is like a pretty big cost, but there's also so many other costs. Like I think there's risk to the grid from poorly maintained parks. Um, the lack of incentive for energy efficiency in parks probably contributes to capacity, especially since manufactured homes tend to not be that efficient. And so no use of like time of use plans or things like that. Um, there's reduced revenue from less basic service charges and a lower per kilowatt hour rate. So I think utilities are like financially suffering from this too. And that, of course, gets passed on to customers. So I think it'd be great to figure out how to quantify that to gain some like political will to like really address this issue long term.
That's a great point. I think you could also look at like, it's not just call center, but then you've got call outs to those locations, right? Like I was saying, like when troublemen get called out, they're at a high billable rate. And they're by having to go out to locations like multiple times to see, have you actually repaired the equipment so that I can flip it on or not? That's another cost to consider. And then damage the transformers, which are what step down the power coming into the park. So
Thanks so much for sharing, Mariana, and for all the research you did coming up to this point. That connection between with the impact on eviction rates, I think is really, really important.
yeah, thank you. Sorry, I'm a little rusty on the statistics, but I would also like to say that TEP was great in sharing information with me. I worked with their senior attorney, and who has since retired, but he was great. He read my paper too, so I know that it was front of mind for him. So I appreciated that. So I just wanted to point that out.
You worked on another project, didn't you? When you were an intern at the city
I did, yes. I
with
worked
Jess?
on the AARP project, right, Jim?
Yeah,
Yeah. So I worked with Jim before, which I really appreciated that time too.
that had to do with the city's age-friendly
Mhm.
action plan.
Yeah.
And she and another intern did significant research on the recommendations that have not been fulfilled in that 5-year plan. And
Oh man.
that evaluation is still going on, and the recommendations are still before the city. And so we're starting to contact council members to make them aware, since they were not around when the 5-year age-friendly plan was adopted, that there's still an obligation there. So thank you for all your work on it.
Yeah, thank you, Jim. It was nice to see your name pop up on the meeting. So yeah, I was wondering if that was you. And Kath, I would like to say if I can help in any way with any research or just consolidating information, happy to. Ray, if you want to connect us. I know you're really good at that. Please do.
Thank you. I'll give a quick intro to Christina will be joining in a few minutes, I believe. and anyone else who has met with her has context. I'm looking at who's in this meeting right now. So Christina is the manager of the mobile home park oversight program for the state of Colorado that Andrew from the city of Tucson has spoken about a few times here. See if Andrew's in this meeting. I don't see him yet. But anyone else, feel free to jump in if you want to share more background. This is a department through the Office of Local Services. I'll get the exact quote on that. That in some ways is like the corollary to the Arizona Department of Housing, not exactly, but some aspects of it. That in 2019, oh, there's Christina, great. Welcome, thank you so much. I was just giving a little intro to the background of this, but could actually pass it over to you if you want to give your own intro to what MHPOP is.
Sure, happy to do that. Thank you, everyone, for letting me join your meeting today. I have a few slides. If it's helpful, I can present.
You can now share your screen.
Let me just get that slideshow view up. Okay. Okay. So hi everyone, my name is Christina Kostelowski. I'm the program manager for the Mobile Home Park Oversight Program in Colorado. Our program is housed in the Colorado Division of Housing, which is part of the Department of Local Affairs. So the Department of Local Affairs has our Board of Assessment Appeals, Division of Local Government, as well as the Division of Housing. Oh, I think I am sharing the wrong thing. So I opened the link. Give me a second here. I just have too many tabs open here. Okay, I think I'm back on the right thing for y'all. And folks see the slides? Okay. So I was asked to just provide a little bit of an overview of our program, maybe some lessons learned, depending on what questions, specific questions or feedback folks have. I'm happy to follow up with an email or come back to another task force meeting too for some more detailed information. So I'm just going to introduce the program, talk a little bit about the types of complaints we investigate, how we got started, what our process looks like, what the results are, and then, yeah, happy to answer questions or comments as time permits. So these are some of the responsibilities of our program. We register all mobile home parks in the state on an annual basis. Before the program was created in 2019, there was no central database or repository of contact information for mobile home parks. So it was often a pain point for local governments, or we got feedback that it was challenging to communicate sometimes with the property owners or managers, particularly if those contacts changed. So that's in part one of the purposes of the registration program, so that relevant entities can get in touch with property owners when there are questions or concerns that come up, or even if someone is looking for vacancy in a mobile home park. The registration portion of the program is also how we're funded. So we are funded through the registration fees. The landlords pay a registration fee for each resident-owned home in the community, and they can pass on up to half of that fee to the residents. So the fee was initially set at $24 for each tenant-owned home. The idea being then 12 could be paid by the landlord and 12 could be paid by the resident. The landlord could pass on up to half, so $1 a month. We know sometimes that pass on of the fee to residents is still a challenge though for folks. And we are having our first fee increase this year. So we're in year 6 of the program, and we are having to increase our fees this year by $10 per home. So we educate both landlords and homeowners and residents about the laws. There is a homeowner opportunity to purchase law in Colorado that was passed in 2020. That if a mobile home park is for sale, landlords have to provide 120 days advance notice, and homeowners have an opportunity to form a co-op and make an offer to purchase their park. So we monitor compliance and take complaints related to that law as well. Colorado Division of Housing as a whole also has a grant and loan program that provides some funding support to resident-owned communities. There was a piece of legislation adding some, earmarking some money, some state money specifically to help residents buy their parks. And I think we have about 20 communities now that are owned by resident groups, nonprofits, or local governments. We also receive and investigate complaints. Through the complaint process, attempt to resolve disputes between landlords and homeowners, and then where a resolution cannot be reached, we can issue notices of violation requiring the respondent party, which is typically the landlord, to take actions to cure the violations. Part of the selling point for the program, I think, to the state legislature was that it would be open to complaints from landlords and tenants, and that we would be a neutral party. 6 years in, I think we've received by far many more complaints from residents than landlords. And the way that our law is written is really focused on the homeowner and resident rights. So I don't think that if you spoke to mobile home park landlords in our state, that they would feel like the complaint program has been particularly beneficial to them. Residents, I think you'd find some people have found it very beneficial. Some people have been frustrated by the time it's take to reach full resolution on some of the complaints because of the staffing in the initial years of the program. We started with a very small staff, and then there is an appeal process, an administrative appeal process that can take a year or more. But I can talk a little bit more about that as we go on. So we had a state mobile home park act, parts of the mobile home park act, well, and we still have parts of the act date back to the 1970s and 80s, but there was never a agency tasked with specifically overseeing and enforcing it. And so a group of resident advocates requested a sunrise review of our Mobile Home Park Act to see, was it being followed? And they specifically were looking at whether to require mobile home park owners or operators to be licensed in the state. So the outcome of that report is that another state agency, Department of Regulatory Agencies, identified that harm was occurring in mobile home parks due to either lack of knowledge or lack of enforcement of existing laws. The recommendation ended up being to not to license parks, but to task an agency with enforcing existing laws. This led to the bill that created our program in 2019. I will know that since 2019, there have been, I think, 6 other bills that have made tweaks to our program or to oversight of mobile home park operations in the last 6 years. So in Colorado, the program has been refined through legislative changes a couple times as it has evolved. The other addition in Colorado that was done through legislation is there was the creation of a mobile home park water quality testing program and plan. So another state agency here, Department of Public Health and Environment, was recently instructed to test water quality in every mobile home park in the state and come up with an action plan and enforcement for any communities with water quality issues. We work with CDPHE and communicate with them on the water quality testing, but we do not oversee or administer kind of that part of mobile home park oversight in Colorado. So I talked a little bit about our staffing changes and growth. So we started with, I think, 2.3 equivalent of 2.3 full-time employees assigned to the program. And the reason the staffing was so small to start was in part to keep the costs of the legislation down and get support for the program to get created and get off the ground. The second year of the program, we were allowed to grow to 4 FTE, and we've added staff pretty much each year since then, as there's been a need for additional staff positions. We're at 12.5 staff right now, and that's going to go down to 10.5 after 2 positions we have that are term limited expire. So I think one lesson learned for me around the development of the program is we really needed more people at the beginning, or we needed a longer window to get the program up and running before, like, so that we could have more staff on board when we started taking complaints. So the legislation was passed in May of 2019, and it had a safety clause, meaning it went into effect immediately. We were required to start accepting complaints May 1st of 2020. So in that year, though, we had to hire staff, identify an attorney, and then a big piece of it was we had to work with our Office of Information Technology to build the database that was going to keep track of all of our park registrations and complaints. And so for any other jurisdiction looking at doing something like this, there is urgency around getting residents' issues addressed, but make sure you give yourself adequate time to create the tools and have the people in place to be responsive. Because when we got a ton of complaints in 2020, we were still trying to register all the parks for the first time. So unless a complaint was about an eviction or a utility outage, a water outage, it didn't get touched probably for at least a year. And that created disappointment among folks who wanted to use the program and was hoping that it was going to address their concerns. We have done a huge amount of work in the last year and a half to resolve older complaints and make determinations on them. We have since 2020, so 5.5 years since we started getting complaints, we've gotten over 1,000 complaints. All complaints all complaints filed before this calendar year have now been resolved. So we are finally current on complaints. Colorado communicated with Washington State, which also has a complaint program for mobile home parks around the development and early implementation of this program. And unfortunately, they expressed a similar issue where they had a lot of complaints before they could adequately address them. And as a result, they had cases from early on that, somebody no longer lived in the park, somebody passed away. So we're just, the cases had to be closed, unfortunately. So it's hard to balance the need to get help to folks now with also wanting to make sure you're in a place to provide that service. Another component of our program is all landlords are required to post and share a notice of homeowner and resident rights in common areas of the mobile home park. Our statute outlines some things that specifically need to be included in the notice, like information on evictions and information on filing a complaint with and contacting our program. It is required to be posted in English and Spanish, and through rulemaking, we have also required that landlords distribute it each year, either by email, post mail, or posting on doors. We have, in the early years of the program, we received some complaints that landlords were not doing this, or it was posted and then it was taken down, or something happened to it. Only one page of the notice was posted, or wasn't posted in Spanish. So this led us, I'm going to say, to 2 years ago, hiring 2 compliance investigators who we had travel around the state to check if the notices were posted or not. We issued a lot of fines as a result of that, that landlords were not very happy about. But the way our statute is written, if we find out the notice is posted, we are required to assess a fine. We think that compliance has improved a lot since we did those checks and those initial round of penalties. We also did additional education for landlords on where the notice has to be posted, how it has to be posted. It can't be inside a locked building. It has to be outside. If it's outside, it needs to be behind a plexiglass or something to protect it from the weather, or it has to be replaced, if it gets sun damage, water damage, things like that. We receive complaints. I mentioned homeowners and landlords. One of the expansions of our program was to also allow residents who are renting a mobile home to file complaints, as well as nonprofits and local governments. Because of the way our Mobile Home Park Act is written, we can probably do the most if someone is a resident homeowner and files a complaint. Renters have other rights that aren't included in our Mobile Home Park Act. So for example, if there is an issue inside the home and someone's renting the home, that would be outside of our program and under another state law for warranty of habitability. So what we do in those situations is we have a list of attorneys and legal service organizations that we can provide to residents. Maybe we can address an issue with the water service to their home, but then an issue with their water heater in their home, they'll have to speak to an outside attorney about that. The goal of our complaint program and the way that we've approached this is to resolve disputes and make sure everyone is following the law. Our goal is not to simply punish respondents. Although we do have the power to assess some pretty significant penalties if a landlord is not cooperating with the program. Another thing that was added to our program in it's kind of two different pieces. I think once was in 2022 and once was in 2024. There have been a lot of bills. There are certain things that landlords need to do to be in compliance in order to increase rent. So if a landlord is not registered with us actively, they can't increase rent. If they have if there is a government order against them and they have not completed all of the actions from that government order, they are not allowed to increase rent. If they have an unremediated water quality issue, so where they have received violation notices from our public health department and are not actively working to address the issues, they cannot increase rent. There were efforts in Colorado to put a cap on the amount that landlords could increase rent in mobile home parks across the board. That was vetoed by our governor a couple of years ago. And rent caps have just been a tough issue to get passed in Colorado. But there are these provisions that say, okay, if you're going to keep increasing rent, you have to be in compliance. Our investigative process is largely done through written communications, phone calls, and site visits to the mobile home park. We do have the ability to subpoena respondents for documents and testimony and evidence. And so we started the program making softer requests to landlords. And then we ran into issues if somebody didn't respond or didn't respond fully, it delaying investigations. And so now we do send subpoenas out pretty much in every complaint to ensure that we're getting or help ensure that we're getting timely, complete responses. If a landlord doesn't respond, or a homeowner, if we were to subpoena a homeowner, although in most cases we're sending subpoenas to landlords, there are per day fines in our statute that we can assess for every day they don't respond. So results of complaints, in some cases, we can get the parties to agree to settle the issue. In some cases, the parties will agree to resolve it on their own. Some of the complaints we get are a resident has made a request for something to be fixed in the park, a tree to be maintained on a lot, and the landlords has said they'll do it, but it's taking months and months. And so sometimes the complaint into us just gets the landlord to complete that thing that they said they were going to complete. In other cases, there's not agreement between the parties that there's an issue, especially if it's something that's a bit more expensive or more challenging for a landlord to complete, like regrading a lot. We've seen a lot of landlords resistant to regrading lots to ensure adequate drainage, even though that is a requirement in our statute. So if we can't find a resolution between the parties, we will make a written determination, and we can say whether a violation occurred, what the respondent needs to do to fix it, when the respondent has to do it by, and then what penalty will be assessed if they don't do it.
Can I jump
We
in with a question there, Christina?
Yeah, of course.
Do they go through a court hearing then, or how much burden is it on the tenant versus what your department actually does the investigation yourselves?
Yeah, that's a great question. So after we issue a notice of violation or non-violation, either party can request a hearing on our decision. And that's an administrative hearing. So it isn't a court, an administrative court before an administrative law judge. If, say, we issue notice of violation against a landlord, the landlord appeals it, the homeowner is not a necessary party or automatically part of that appeal. So the Department of Local Affairs will defend, and we're represented by an attorney in our Attorney General's office. We will defend our decision, our determination in that hearing with the landlord. The homeowner can, may want to be a witness in the case, or we may ask them to be a witness in the case. The homeowner can also file a motion to intervene and also be a party to the case. We've had that happen in one case so far where a resident association filed a complaint with the help of an attorney. And so they ended up intervening when the landlord appealed the decision. So they were also part of that hearing. But it's not a requirement for the residents to be involved. We will, because really what the court looks at was then we have the burden of proof at the division of showing that we made the right decision in that hearing. Some common complaints we get, and I'm almost done here on slides. Some common complaints that we get related to failure to maintain water, sewer, or utility lines. I read the article that came out, I think, yesterday about the lawsuit in Arizona against a park with repeated electrical outages that your AG's office is bringing. We have that kind of frequent issue with water outages in some of our mobile home parks. Failure to maintain trees in the park is another common complaint. We have had a couple of cases where folks have had damage to their homes that was pretty severe as a result of tree branches. Many other cases are concerned that that's going to happen if the tree doesn't get adequately trimmed. So we have a lot of cottonwood and ash trees that pop up all over and provide great shade, but really can be dangerous for mobile homes. And then we do get complaints alleging that homeowners have been retaliated against by park management. in our Mobile Home Park Act, part of the legislation in 2019 and 2020 was to include some strong anti-retaliation provisions and say, if somebody files a complaint, you can't retaliate against them. This is what retaliation looks like: selectively increasing rent or decreasing services, selectively enforcing park rules or surveilling residents, etc. One challenge, oh, and then if we find a landlord has retaliated against a homeowner for making a complaint or for otherwise exercising a legal right, we can assess a fine up to $10,000. So a pretty significant fine. One of the challenges we've had around the retaliation provision, I love those smiles, is there are cases where folks just don't have a good relationship with one another. And it's not retaliation under the statute. And that can sometimes be hard to explain, that you have to be exercising a legal right in order for it to be retaliatory. Sometimes there are mutually bad relationships between on-site managers and residents, for example, that wouldn't fall under this legal category. The last thing I wanted to share was just two slides related to lease terminations in mobile home parks. So one thing in Colorado's law, homeowners can only be, their tenancy can only be terminated for cause. So a landlord can't just say, you're a homeowner in this park, but I don't feel like renewing your lease. The leases automatically renew for a month-to-month period until the landlord has a specific reason that's listed under the act to terminate the tenancy, or until the homeowner decides and provides notice that they wish to terminate the tenancy. So before 2020, before the bill that passed, there was a bill that passed in 2020. One of the for cause reasons for terminating a tenancy, though, was something along the lines of being an annoyance to others in the park. So that is a very low bar, right? And especially if there's just a bad relationship with a neighbor or on-site manager. That was taken out of our law in 2020. And another common way that people's tenancies were terminated was for park rule violations. That was changed to now, this last part of the language here, you can only terminate someone's tenancy for park rule violations if the rule is necessary to prevent material damage to people or property or health or safety. So if the park has a rule that you can't paint your house pink, they can't evict you if you paint your house pink. Or they would have to make an argument for why having a pink house materially damages other people. One piece of feedback that we've heard from landlords, and I heard very recently, was that they feel like they don't have tools to enforce their rules now. So, if this were something the city of Tucson were to pursue, I would expect similar feedback. So here are some of the specific reasons why a landlord can terminate a homeowner's tenancy in a mobile home park in Colorado. On the second to last bullet, non-payment of rent. This does not include non-payment of utilities only. So legislation was passed last couple years in Colorado, 2 other pieces of legislation. I'm happy to send a list of and links to bills if for folks who want it. But there was legislation passed saying that you can't evict people in Colorado, and this is inside and outside mobile home parks, only for having past due utilities. There has to be past due rent, and any payments you get as a landlord, you have to apply those to rent first. You can't apply them to utilities and then use that as an excuse for saying the homeowner didn't pay rent. There was also a specific section added to our Mobile Home Park Act on water billing that says that adds more transparency to water bills specifically, saying the landlord has to disclose how much they paid to an outside provider, how much they charge the residents as a whole, in addition to disclosing how much they're charging you each month. Because we've had what I heard are some similar issues with just some utility bills that don't make any sense in mobile home parks. So I'm not sure if I went way over time or way under time. I hope this is helpful and answered, questions, or is good for an initial conversation. I'm happy to chat more depending on how y'all's time allows.
I think you're perfect on time. And we do have we do have plenty of time for questions. People have questions. As long as you do.
Can you hear me, Ray?
Yes.
Oh, no, I have a comment. When you mentioned that the landlords were saying they didn't have the tools to enforce their rules, they've been wielding eviction as the primary tool. They do have the ability to fine, I would believe, if someone has broken a rule, don't they?
So how we have come, I mean, you're absolutely right about eviction being the biggest tool. And while the Division of Housing is a neutral party in these complaints and the program is neutral, we are part of a division department that has a mission to strengthen affordable housing and keep people housed. So we don't want to see people evicted because they have the wrong type of curtains or a window AC unit or other examples like that. In Colorado's law, we have two things. One provision says that all charges to the homeowner have to be in the lease. So if they're assessing a fine that isn't contemplated in the lease, we would likely tell the landlord they can't assess that fine if that came up in a complaint. There is another provision in our law that says landlords can't charge entry fees, but then defines entry fees as any charges other than rent, utilities, government fees, or charges that are reasonably related to a service that is actually performed and agreed to in writing by the homeowner. So we've interpreted that as prohibiting, say, a $300 fine for not mowing your lawn. Now, a landlord, if it's in their park rules that you might be charged for lawn mowing if you don't mow your lawn in X amount of time, may be able to charge a reasonable amount of money for the work to mow your a resident's yard, but they can't just assess punitive fines. At least that's been the position of our program and how we've interpreted our law. So they are upset about that. They're upset that they can't be more, I think, punitive to try to get more people to comply.
I see. Thank you.
Christina? Arizona doesn't even have a list of parks and park owners that I can find. Maybe somebody else knows about it. If you do, please tell me. But they don't, the Department of Housing, nobody has a list. The only place you can get it possibly is by like going into the tax department or I don't know, something about land, who owns the land or something like that. But it's really complicated. And I don't know if you have any suggestions on how to put together such a database, but boy, it sure sounds like a difficult thing to do. I think we need to do it though. Anybody know any of such a database in Arizona?
Nope, that's the problem.
Okay.
Yep.
I'll mention that how we put together our initial list of landlords or landlord contacts to send registration information to is we sent letters to all of the county assessors and asked them to send us information. And we got a lot of information from the county assessors. I think all but one county responded to our requests. But then we had the process of getting all the parks to register and have through over a couple of years then worked through, okay, we had the wrong address. This was the wrong owner. Oh, this wasn't on the assessor's list, or this was, but it doesn't meet our state definition of a mobile home park. So the county assessor information was definitely the starting point, but took a lot of effort to compile that into one place and then, check the data for accuracy.
We have a question in the chat in Spanish. We might take a second for the interpretation to catch up, and then Monica, if you'd like to ask your question out loud.
Something about rent.
¿Lo quieres preguntarlo, Mónica?
I can make an attempt to answer the question if helpful, and if the interpreter can translate it for Monica and others. So the challenge with the rent cap has been different policy views, even within Democrats in our state or among Democrats in our state, about whether rent control or rent cap solves the lack of affordable housing or affordable housing issues. So our governor has really wanted to focus on, and we have a Democratic governor, he's really wanted to focus on increasing housing stock. And so that was a big focus. Well, during COVID, it was eviction prevention, trying to keep people housed, and rental assistance. After that, we had something called Proposition 123 that was focused on having all local governments set goals around affordable housing stock and then giving local governments money to implement that. My understanding, and this is just my understanding, not the position of the division or the governor or anyone, is that one thing rent control can do well is keep people housed where they are while you're waiting for more housing to be built. But there was a lot of pushback from landlords around rent control, and there were a lot of arguments that were being made that it was going to make housing even harder to find because people were like landlords were going to leave the rental market. That's kind of my understanding at a high level of what the conversation was that happened here. But in Colorado, even local jurisdictions are prohibited from implementing rent control or rent caps at the local level.
Same here.
So I mean, if you're advocating for rent caps or rent control, I think one of the strongest arguments or evidence is, yeah, but people are going to lose their houses now if the rent goes up again. We need to keep them housed until we have more affordable housing available. That argument hasn't worked yet here, but I know that's what some of the advocates here have been trying to bring home.
Another issue we're facing here in the park I'm in addition to tremendous increases in the amount of rent being charged, they have changed the requirements for those of us who want to get out, want to sell. They have changed the requirements for how a new buyer would qualify. For example, they now, I believe, require 3.5 times the monthly rent as your proven income. We are in a low income area. We have a lot of retirees. The rent is 900, it will be 905, and different people pay different amounts, which is another issue. Plus utilities, anywhere from 150 to 450. So you're looking at maybe 1,400 or 15. I think they just calculated on the rent. So you have to have 3 times the 905 or 925 or whatever they're charging, which eliminates a tremendous amount of people from purchasing. And that isn't being addressed in any way that I know of.
Not at all.
There are some sections of our current Mobile Home Park Act, again, added in the last 5 or 6 years, that limit the landlord to requiring that limit what the landlord can require if someone's trying to sell their home to another person of the buyer. I will put in the chat the language. It looks like the landlords here can require evidence of income that's at least 200% of the rent, or cash assets that are at least 200% of the rent for 6 months. What the landlords really pushed for around this legislation is they expressed concern to lawmakers and I think lawmakers took this feedback to heart, that they didn't want to set somebody up for quote unquote failure. So they didn't want to start a lease with somebody that was going to end in a tenancy termination for non-payment of rent, in the next couple of months.
Yeah.
But 3.5 times the income, that doesn't seem reasonable, especially when many of the people, probably the majority, are on Social Security.
Yeah.
So you're stuck. If you're a homeowner, you maybe can't afford to pay the rent, and you can't sell because people can't afford to buy and pay the rent. So then what happens is people walk away, and the park ends up confiscating the home and selling it at a profit.
Yeah. And I think the 200% does represent a compromise between what it was before in many parks.
Yes, it was before. It was that.
Quería preguntar a Mónica para asegurar que ese sí contestó su pregunta. Y otra cosa que usted habló, Cristina, es con con el acuerdo que tiene, algunos de los parqueaderos sí son limitados en lo que pueden cobrar, ¿verdad? Porque sí han tenido ¿qué es la palabra? Una infracción. No puede subir la renta este año. No sé, Mónica, si su pregunta fue sobre eso o sobre el control de la renta en general.
Sí, sobre las dos, un poquito de las infracciones que tiene cuando no pueden subir lo de la renta y cómo es que llevan eso y la otra en general que estaba explicando hoy.
So I can share for the parks that are prohibited from increasing rent because they are out of compliance with something. We actually publish on our website a list of those properties to try to help people be aware of whether or not their park can increase rent. And you'll see a lot of parks that have outstanding penalties that are owed to us on that list, and that being a reason that they're not permitted to increase rent.
Where you been?
And some like outstanding compliance issues. One interesting thing, and this was one of the recent changes to the law. So we have a section of our Mobile Home Park Act that focuses on the landlord's responsibilities to maintain the park. So things like the utilities, water, roads, snow plowing, trees, all of that. If a landlord is found to be in violation of those maintenance responsibilities specifically, even if they correct them, if we issue a notice of violation, they're not supposed to, that becomes final. They're not supposed to increase rent for 12 months after that.
Great.
And it's to address, complaints that we heard and legislators heard that they keep increasing their rent and they've done nothing to improve the property or maintain the property. One of the weird quirks we've seen with this provision on the program side is we're issuing notices of violation that include this section of law, which is 38-12-212.3. The landlords are appealing and then trying to settle with us for exactly the same terms in the notice of violation so that they can still increase rent. And that's put us in a little bit of a tough position because, the intent of this section of the law was if you have a notice of violation that's finalized, you can increase rent. But we also want to get whatever the maintenance issue is resolved for residents. So we've had some cases where it's like, this is going to be resolved faster if we settle But then if we settle, it's an exception to this 1 year rent increase prohibition. The homeowner advocates wanted to write this provision initially that just if we issued a notice of violation, they couldn't increase rent for 12 months. But I think landlords successfully pushed back on that because there was concern about, their due process rights. So what if our notice of violation was completely bogus and unsupported? So that's why it ended up getting changed to there has to be a final agency order, and then there was this carve out if they settled. I don't know what's going to end up happening with that. We've kind of raised that internally as like, hey, this is a weird issue that's also increasing our legal costs and maybe not resulting in what was intended for residents. But just sharing if that's something y'all ever look into.
Yeah. Could you shorten the length of time from 12 months to 90 days or 6 months, something like that, and do a compromise?
In terms of no rent increase?
Right.
So we had legislation also passed in Colorado the last couple of years that says landlords can only increase rent once every 12 months for month-to-month tenancies. So they're limited to that frequency anyway. I guess depending on when a notice is issued since their
Yes.
last rent increase, it could just kick it back up to another year.
That's 22.
Yeah. Well, it sounds like you guys have really done a great job. I look forward to implementing this in Arizona. You got the bugs worked out.
At least the mobile homeowners
Hopefully.
have representation.
Yeah, and there are some I think really strong advocacy groups here, made up of mobile homeowners, working with mobile homeowners, that have kept this issue alive and in front of state legislators, for the last 6+ years, because they were advocating for this program or for legislation to preserve mobile home parks for several years unsuccessfully in terms of getting a bill passed. Because 10, 15 years ago, our legislature was Republican controlled. The last 6 to 8 years, it's been pretty strongly Democratic controlled. And that that was the change that got the bills to pass finally. But I think, and you would have to talk to some of those groups, but I think the organizing they did, the advocacy they did before they had the votes to get the bill to pass was still valuable, and they learned a lot from it and built a coalition that has continued to work on these issues and try to push us to be better in this area too.
Great. Thank you so much.
Anyone who hasn't had a chance to speak today, or I know the Spanish interpretation always has that delay. So I wonder if anyone else in the Spanish room has any last questions or comments.
Ray, I'm sorry, I'm not very computer literate and I don't know how to respond to Kath's message to me. But if she can send me a phone number or whatever, or I can send her one, we can get in touch.
I put my email in there, Jan.
Okay, I'm sorry. It flashed on and off and I didn't have time to write it down.
Oh, it's under chats at the bottom of your screen. Put the mouse down at the bottom of your screen and see chat.
I can connect you two both over email too.
Yeah, yeah. If you could, Ray, I would appreciate that because I can't get to the bottom of my screen.
Okay. Thank you, Ray, for pulling this together, or whoever did it.
Yes, it's wonderful
Mhm.
to have a
Thank you
model.
so much.
My brain is spinning.
We don't have a ton of time to talk about next steps, but one of the things I want to propose for today is to have a committee that's really working on investigating the laws in other states. And Christina, thank you so much for taking the time to talk us through some of these. And we'll definitely take you up on an offer of the laws you think we should focus on looking at. I did see the ones on your website. We'll make sure to read those. But if there are other suggestions as this group thinks about our policy priorities and for what we might be trying to push forward as legislation for putting some better protections in place. If anyone else wants to support with doing some of that behind the scenes research over this month, if you want to drop a note in the chat, maybe we can get together over the next few weeks and have something ready to present for our in-person September meeting.
Thank you to Christina too for everything she has done and shared with us.
Exactly.
Well, thank you all. I'm excited to see where you go, and we'll be following that state level case in Arizona as well to see how that turns out.
There'll
Christina,
be more cases.
I'm in Gunnison right now, Christina.
Oh, nice.
Yeah, it's lovely here. So
It is beautiful. They have a great community and economic development program in Gunnison. Their leadership there has really been an advocate for mobile home park residents.
cool. That's
So,
neat.
hopefully not too many fires, or the fires are mostly contained. Okay.
It's been raining actually.
Good.
Thank you. Okay, I think I'm gonna go. Are we
Take
done?
care.
Thank you everyone so much.
Bye-bye. Thank you. Thanks, Christina. Wow.
I'm still working on that master meters in California.
Oh yeah.
Yeah.
Right.
So I've been burned out this summer, but I'm getting my groove back.
So Ray, I had shared with Mary Alice and I think with AMHO about 3 years ago, a law in California. So if a park decides to change the use, to sell the park and change the use, they must pay fair market value to each resident for their home. And I sent that legislative law number to Mary Alice and asked her to share it with everyone. I don't know if that ever came about, but my greatest fear was that I would lose my investment here because they kept selling this park, and the land is worth a lot more to put condos on than it is for a mobile home park.
Yep.
So that would be maybe another legislative area to look at. So we don't get slammed like the park on Orange Grove did when they sold it to a developer to develop condos, and everybody lost what they had in there. All the homeowners didn't get fair market value.
It would be a great thing to have on that list.
I'll look up that law number and send it to you. The one that's in California, that would be an example of it.
Perfect. I need to some kind of format for putting laws in to be able to organize what the different laws are in different places that we might want to base things off of. I'll talk to Elise and see if she might be willing to help create
There
that
you go.
structure.
Yeah.
And then for us to be able to then like plug it in of saying like, okay, here's the laws that we like about tenant opportunity to purchase. And here's the laws we like about, now I heard in Colorado and in West Virginia, in both of those states, they will not allow evictions based off of utility non-payment.
Yes.
Rent has to be that any payment applies first to the rent, and you can't evict over non-payment of utilities.
We have to get that clause.
Yes.
I wonder how they figure that out of what the consequences are eventually for non-payment of the utilities.
Ray, is there any data on the percentage of people who are evicted from mobile home parks are evicted solely because of non-payment of overcharged utilities?
No.
I don't even think we have data on how many evictions of mobile home park residents
Right.
we
Right.
have. We certainly don't on that. It's not one of the things they track in eviction court.
Well, isn't there just one judge that rules on evictions
Yep.
In
Newman.
county.
in Pima County?
Yeah.
Yeah. Isn't there a public record on how that judge has ruled in favor of residents versus landlords?
Oh, I would be very interested in that. Hmm?
I've heard, and I this is just hearsay, that the majority of the rulings this particular judge has made have been continually in the favor of the landlord, and you can just forget it. I was advised by legal aid to not fight anything they were doing to me because he was going to rule for my eviction if they filed
Yep.
against me.
I'll bet it's 98%.
That's what I was thinking too, but that would be an interesting statistic to have. Someone like that shouldn't be in the court system doing evictions. They obviously are not impartial.
Not at all.
But secondly, it goes right to the heart of the homeless and unhoused situation here.
Mhm. I do know that the average time is 3 minutes. The eviction takes 3 minutes.
Well, because he's already made up his mind, maybe. But I mean,
Exactly.
it'd be nice to have statistical information on what's happening.
Yeah, I believe IHSL probably has that, or HSLA.
I'm
'Cause-
not familiar with any of that, but I think they do have,
Yeah.
there's always a record of how judges rule, but I just don't know
Yep.
where that record is.
Yeah.
Thank you all so much. And thanks HCD for holding.
All right, I'm losing you guys. I'll see you next time.
Thanks, Ray.
Yes, yes.
All right, thanks, Ray. Bye, Jen.
Bye.
Thank you.